This podcast reviews ethical issues related to prosecutors, to the lawyers who prosecute criminal trials. And we're going to talk a little bit about the general ethical duties governing prosecutors. We'll talk about the lawyers' or the prosecutor's duties with respect to providing disclosure to the accused. And we'll talk about prosecutors' exercise of prosecutorial discretion. And we start by noting that, generally speaking, we talk about prosecutors as being a quasi-judicial minister of justice. And the case that's most often cited for this proposition in Canada is a case called Boucher. And they note that the purpose of a criminal prosecution is not to obtain a conviction, it's simply to present credible evidence relevant to what is alleged to be a crime, and that the role of a prosecutor excludes any notion of winning or losing. And we see here a general statement from the codes of conduct that when acting as a prosecutor, a lawyer must act for the public in the administration of justice resolutely and honorably within the limits of the law, while treating the tribunal with candor, fairness, courtesy, and respect. And it incorporates in there the duty from Boucher, that the primary duty is not to convict, but to see that justice is done through a fair trial on the merits. At the same time, however, we also do understand that a prosecutor is a resolute advocate, that in the conduct of a criminal trial, which occurs through an adversarial process, a prosecutor has to act in that capacity. They have to bring forward the case for the Crown. And so one of the things that we need to think about with a prosecutor, and when we understand their duty as a minister of justice, I would argue that there's two ways to think about that. The first is that prosecutors don't have a client. The prosecutor is responsible for determining when and how and in what way a criminal charge will be brought forward. Things that in a civil case or with a criminal accused would be decided by the client. Those with the Crown are decided by the Crown lawyer. That's what the exercise of prosecutorial discretion is about. And when we think about doing that job, we'll talk later, but we have a sense that the Crown is acting in a way that takes forward the interests of the Crown, which are not simply in convicting anyone that you can get into court. And so you want them to look at whether there's a reasonable prospect of conviction and whether the prosecution is in the public interest. That's normally what you do with prosecutorial discretion, and that's one of the functions of the Crown. And so that's really where that quasi-minister of justice duty is speaking to. When a Crown lawyer goes into court, although again they still don't have an instructing client, they are more like a traditional lawyer. They're a resolute advocate within the boundaries of the law. However, a Crown lawyer, the boundaries of the law are going to be more robust because of the benefits of the doubt and the procedural safeguards and constitutional rights that we give to an accused. So a Crown has two functions. One is to exercise prosecutorial discretion, to look at whether there's a reasonable prospect of conviction in the public interest, and the second is to be a trial lawyer in an adversarial system within the bounds of legality, recognizing that those boundaries are more robust for a Crown because of the rights of the accused. Now, what does that mean in practice? In the context of a trial, we prevent Crowns from communicating personal opinions on guilt or using emotional appeals to a jury when they make statements to a court. And so in Boucher, the conduct that was found to be inappropriate was saying that he had no sympathy for the dastards who did crimes like this, that the offense was cowardly, and for once it would be a pleasure to seek a death penalty for this particular accused. And also said, and by the way, we really investigated this case, so you can trust in us in deciding whether the accused is guilty. All of that was said to be improper. And there was also case law emphasizing, and you read one of these cases in the advocacy unit, that it is inappropriate for a Crown, really for any lawyer, but in particular for Crown, to abuse a witness during cross-examination. All of those things are inconsistent with the duties that we impose on prosecutors to be quasi-ministers of justice. That's actually an actual picture that an American prosecutor put before a jury. That is not acceptable. The duty of disclosure. This is codified in the codes of conduct, but arises from case law and requires a Crown lawyer to make timely disclosure of all known relevant facts and witnesses, whether tending towards guilt or innocence. In the United States, this is the Brady obligation. Here, it arises from a case called Stinchcomb. And in Stinchcomb, prior to that time, disclosure was argued to be or was viewed as being largely discretionary on the part of the Crown. But there have been cases, including the wrongful conviction of Donald Marshall, where non-disclosure had contributed to the wrongful conviction. The accused was not given exculpatory information. In Stinchcombe, a lawyer had been charged with breach of trust. His secretary was interviewed twice by the police, but her statements were not provided to Stinchcombe, and the Crown did not call her as a witness. At the preliminary inquiry, her evidence was favorable to Stinchcombe, and the question was what should have happened to her statements, should they have been disclosed. And the Supreme Court said they should have been, and overturned his conviction. All relevant information is to be disclosed. The Crown controls the timing. It doesn't have to disclose privileged information. Informant identity may be protected, but timely, appropriate disclosure of all relevant information, whether exculpatory or inculpatory, is a duty of the Crown. The Crown may rely on the police to provide disclosure. It's not obligated to provide information that it doesn't have or isn't in its possession. But if it fails to provide that disclosure, the Supreme Court held in 2015, the Crown can be held liable under the Charter of Rights and Freedoms, under Section 24(2). And in the case of Henry, when it went back to trial, Henry in fact received sizable damages for the Crown's non-disclosure and the resulting wrongful conviction that he suffered. Prosecutorial discretion, I already mentioned this. It includes all decisions regarding the nature and extent of a prosecution and the Attorney General's participation in it. That includes prosecuting a charge, entering a stay, accepting a guilty plea to a lesser charge, withdrawing from criminal proceedings, not presenting evidence and inviting a court to acquit. But it does not include tactics or conduct before the court or satisfaction of constitutional obligations such as disclosure. It is because, in part, of their exercise of prosecutorial discretion that we say that prosecutors are independent and that courts and the government ought not to interfere with prosecutorial decisions about whether and when to bring forward a criminal case. The key cases on the scope of prosecutorial discretion from which that summary is drawn is the case of Krieger, which I'm going to talk about in a minute, around the role of law societies, but it says that prosecutorial discretion does not include decisions about disclosure. Nixon says that the prosecutorial discretion includes a decision to resile from a plea agreement prior to it having been entered in court. And Anderson noted that prosecutorial discretion includes a decision to seek a mandatory minimum sentence in a case. What do we do about prosecutorial discretion? How do we can control it? And the reason, the answer to that question is because of our valuing of prosecutorial independence, we have very light controls on how prosecutors do it. Prior to a case being held, a trial being held, a court will only review an exercise of prosecutorial discretion where there is an abusive process, where it undermines the integrity of the judicial process or arises from improper motives or bad faith on the part of the prosecutor. Law societies also will only discipline where the prosecutorial discretion arises from improper motives or bad faith. After the fact, after a person has gone through a trial and it turns out that they ought not to have been tried, that it was a mistake, they can bring an action for wrongful prosecution, but only in extremely narrow circumstances. In addition to having to show that in fact they were innocent, that there was no grounds for the charges, that the Crown was the one who brought it forward, they have to show that the Crown had some improper purpose in bringing it forward, that it was deliberately intended to subvert or abuse the office of the Attorney General or the process of criminal justice. Mere negligence or even recklessness is not enough. It has to be a deliberate attempt to subvert the process. Prosecutorial discretion can be reviewed by the executive branch in a commission of inquiry, but of course that doesn't happen very often. Just to note, the two key cases on abusive process are in Anderson. That's where the court said that you can only review these cases where the Crown conduct is egregious and seriously compromises trial fairness or the integrity of the justice system. The applicant has to establish a proper evidentiary foundation for the claim as a threshold matter to even get the court to think about it. But you can review Crown trial conduct when they're just being that resolute advocate within the boundaries of legality, although even there, their tactical decisions are entitled to a high degree of deference. I would note that most lawyers will get an amount of deference from the court in terms of determining whether their trial conduct is appropriate, but this case emphasizes the importance of that for Crown counsel. Krieger was a case of non-disclosure. The prosecutor didn't disclose exculpatory test results. A later internal inquiry of the government found that delay was unjustifiable. And the Law Society initiated proceedings, which Krieger resisted on the grounds that it was an exercise of his discretion and the Law Society couldn't discipline him. And the Supreme Court disagreed. They said that the prosecutorial discretion is, as I said earlier, about whether a prosecution should be brought and what for, about the nature and extent of a prosecution. And that can be regulated if there's bad faith or impropriety. Disclosure has a broader ability for them to regulate because it's not about prosecutorial discretion. It is a more general exercise of the lawyer's legal obligations. It's not discretionary. You have a duty to disclose, and if you fail to disclose, the Law Society can consider whether that failure amounted to misconduct. Prosecutorial discretion, the question then is, well, how do you do it? We've talked about how you review it, but what ought a prosecutor to do? In general, in Canada, there's different guidelines across the different provinces and federally by the Public Prosecution Service of Canada, but all of them require the prosecutor to look at the prospect of conviction and the public interest. The prospect of conviction is really about whether there is sufficient evidence to justify the institution of proceedings. Is there a reasonable prospect of conviction? They use different languages, is there probability, etc. But something about, is it likely that this person will be convicted, taking into account the availability, competence, and credibility of witnesses. If a person was unlikely to be convicted, the trial ought not to go ahead. If there's not even a reasonable prospect, it ought not to go ahead. The public interest requires simply looking at a wide variety of things like the seriousness of the offense, the view of the victim, and so on. The list here is from the Public Prosecution Service of Canada Desk Book, but these are the things that a prosecutor ought to consider. Generally speaking, as I said, we have very narrow review of prosecutorial discretion. I do want to note one case which I think is unusual and kind of an outlier, but just it's in your casebook and to note it. There was a guy who was charged with assaulting his son and given a conditional discharge. He had spanked and kicked the son. And at appeal, the Court of Appeal simply said this should never have been brought. It was within, what was appropriate. And, my parents, this would have been terrible. I can't believe someone would bring a case like this. And so they didn't actually throw the charge. They didn't actually, overturn the conviction. The court simply granted leave to appeal and ordered a stay. So in effect, they reviewed the exercise of prosecutorial discretion. Although, as I said, this is a very unusual case, and I would suggest runs inconsistently with the later jurisprudence of the Supreme Court in the case of R.N. Anderson, and maybe suggest why we don't have courts exercise oversight unless there is an abusive process or a wrongful conviction.